Okay. The March 2022 meeting of the California Law Revision Commission will come to order. A quorum is present, and we're expecting a couple of more members to join us, hopefully soon. First order of business is approval of the minutes from the February meeting.
I move to adopt the minutes.
Questions? Okay, there's a motion. Motion to approve. Any questions or comments from members about anything in the minutes? Hearing none, seeing none. Was there a second?
A second.
A second. It's been properly moved and seconded. Please call the roll.
Commissioner Carrillo,
Aye.
Carrion, Cubas. Hebner?
Yes.
Cubas, yes. Hebner, Jenkins,
Aye.
King,
Yes.
Simpson.
Aye.
Okay, so
Okay.
that's out.
Minutes are approved. Next item is administrative matters, report of the exec.
Okay. Well, I have a few things to report.
Okay.
First of all, as I mentioned by email, we have canceled the April meeting. And the reason for that is that the governor's executive order that waives the requirements of the Open Meeting Act that's effectively preclude this kind of meeting entirely by Zoom is set to expire at the end of March. And I have not yet heard of any replacement measure that would continue the necessary exemptions. So if we were to meet in mid-April without knowing until the end of March whether or not we could do it by Zoom, it just would not be workable. We would be scrambling to figure out how to handle things if in fact the emergency provisions aren't extended.
Right. Find a venue and all that sort of stuff too.
Right. Well, and the other thing is that we had talked several months back about trying, when we do go back in person, trying to do it in a hybrid format where we could have commissioners gather in the Capitol, but have a Zoom session running so that people around the state could participate.
Mm-hmm.
And the technical issues surrounding that are going to be tricky. We haven't yet done like field testing because to date we haven't had to. So now I think we're going to have to come to grips with it. So the interval between now and the May meeting, we'll be seeing whether or not we can figure out how to use these iPads that we purchased to have a meeting that's both in person and remote. And we'll just have to see whether that's feasible or not.
Okay.
You approved a calendar of meetings for this year that was set monthly. And so presumably you've all, to the extent you can, reserve those dates. So if we go back in person, I assume we would also be going back to our earlier practice of having longer meetings every other month.
Mm-hmm.
And so if that were to happen, we could achieve that simply by dropping the off meeting dates and keeping the other ones we already have. So we're positioned pretty well to go in either direction. We just need to know which direction to go in, and I'm concerned that we won't have enough lead time if we tried to squeeze in the April meeting.
Right.
It's also true that with the retirement of Barbara Gall, we're going to be down an attorney, and so it's going to be hard for us. It would be hard for us to produce enough staff material in a 1 month interval to justify the meeting date. So a number of reasons why we will be seeing you again in May rather than April. And then at that meeting, I'm hoping we will have clarity and we can decide what we're going to do for the remainder of the year.
Good. Makes sense.
I'm also happy to say that we've completed the process of doing a couple of hirings. So the Committee on Revision of the Penal Code. Good morning, Commissioner Carrion. The Committee on Revision of the Penal Code had new positions created in the budget for this fiscal year. One of them was an attorney 4. We just filled that. A woman named Joy Haviland, who previously worked for the Office of the State Public Defender. I think that's going to be a great fit, but you won't get to see her. She'll be working exclusively for the committee. And then also a position that was created in the budget a couple years back, but COVID interfered with our recruitment. We just hired an office technician, a woman named Megan Hayenga, who I expect is in the audience. I haven't checked. If so, hello, Megan. And she will be assisting Deborah Larrabee. So we will have two people on administrative tasks, and hopefully that will help us sort of dig out of the administrative backlog that we've had for a while. So that's good news. One other thing I wanted to share that relates to Barbara's retirement. I had been thinking for a while before she picked a retirement date that this was going to present us with an opportunity that's pretty rare for us to think about restructuring the staff. The staffing structure that the commission had going back to 1957 has been pretty static. You know, there's a director, there was essentially a deputy director, and then there were rank and file attorneys. And the addition of the Committee on Revision of the Penal Code has sort of put strain on that structure. So we now have what I just described, plus a separate team of attorneys who do work on an entirely different body of law in support of an entirely different multi-member law reform body. And all of those folks were effectively hired after we'd gone remote, and with the expectation that they would continue to work remotely. And so we didn't constrain the location of their hiring. They're scattered around the state. I think that's going to continue to be their practice, to hire people from wherever. But that makes it difficult for me to take on the responsibility that I have under our current structure to be their direct leader and supervisor administratively. I don't usually see much of their work. They're fairly self-contained and independent in their day-to-day operations. So it's hard for me to evaluate the quality of their work in order to do performance evaluations. They also want to take a more active role in recruiting their own staff, et cetera. So I've proposed a restructuring of the staff. I shared it with our chair, Rick Simpson. I shared it with the chair of the committee, Mike Romano. I've showed it to the Department of General Services, Human Resources, and the Department of Finance, and they're all fine with it. And I will show you, I will share a file that shows you what I'm talking about. And I'll say before I do that, that the reason I'm going into this explanation, aside just from the value of letting you know what's going on with staff, is that there, you know, after Barbara's retirement, I got a question from a commissioner about whether possible applicants for her position should be referred to me. And it's a little more complicated than that, because under this restructuring, I'm actually proposing to eliminate her existing position. So let me share the file, and then if you have any questions, I'll explain it. And then if you have any questions, we can talk it through. Hold on just a second. Okay, let me know if anybody can't see this. Okay, so the top half here, the current staffing structure. Up here, these are the managers. These are managerial classifications. Me, the executive director, chief deputy director, that was Barbara. I've highlighted her in yellow, and I've got a red line going down because her position under this plan is going to change. Underneath the managers or the admin team, this is Deborah as the chief. You have a vacant position, and a vacant position, and we just filled the other office technician, so that's Megan. Over here, we currently have the civil law team, an attorney 3 and an attorney. Over here, we have the criminal law team. There's actually, this is a little dated. They actually have 3 positions filled and 1 vacancy, and I've highlighted the vacancy because, again, that's the position that's in play. So as you can see, with this structure, and I am responsible for supervising everybody in the agency, and that's just become a little bulky with the degree of sort of independent articulation that the criminal team has adopted. So here's the proposal. Eliminate the Barbara's position, so management would be restricted to me, and then reclassify Barbara's position as an assistant chief counsel for the civil team, reclassify this vacancy as an assistant chief counsel for the criminal team. This is a classification that is supervisory managerial. And so those positions it will be permitted for them to directly supervise the rank and file attorneys in their team. So effectively what I'm doing is devolving Barbara's position and splitting it so that there is part of the functions that the management team used to provide will be pushed down and embedded organically into the different attorney teams. And I think this will, especially with respect to the criminal law attorneys, it will make it much easier for meaningful supervision to take place when they are operating, as I said, fairly independently and remotely. We still have attorneys there that I've never met in person. We hired them on Zoom, they've worked on Zoom, and that's not the same thing as like having the day-to-day that would be possible under this structure. The reason it's possible for me to think about this now is because we have the luxury of having 2 vacant positions that can be repurposed, which is almost unheard of for us. We have so little turnover. And I'd like to take the opportunity to do this. I think it puts us into a more stable posture for the future. And also, frankly, it's not inconceivable to me that at some point the criminal team might get split off and become its own entity. And I think it would be good to have some experienced supervisory managerial staff embedded within that structure so that if they do get split off, they're better able to stand on their feet. So does anyone have any questions about this?
I think so. Just maybe one, what wasn't clear, the committee on the revision of the penal code, is that an ongoing body or is that a time limited body?
It has no sunset date. It is nominally ongoing, just like we are.
Okay.
Subject to annual appropriation in the budget for continued operation.
Okay.
The reason I make that caveat is because, you know, I think that their posture is probably a little more precarious than ours. If the winds of politics in Sacramento were to shift sufficiently, then it would be quite easy for them to zero that program out. But as of right now, it's designed to be permanent.
Okay.
I see a hand up from Commissioner Carrion.
Good morning, everyone, and good morning to the public that I can't see. My apologies for running a little bit late.
Not a problem.
This is my first meeting, so I apologize for that. I had a question regarding our workload. I recognize that the criminal law team has already had 2 vacancies, so that the commission staff has been understaffed in terms of it, fulfilling its duties and obligations. You mentioned that the assistant chief counsel will be a supervising and manager staff. How is that going to impact the actual production of work, or is that going to play any role with the capacity of the team being able to effectuate their duties?
Yeah, I don't think it will have any effect on the commission's staffing, because when the committee was first conceived and effectuated with budget bill and budget trailer language, I was consulted about how to do that without burdening the commission. And so like I said, they operate mostly independently. And another thing that is a point of distinction between the committee and the commission is that the committee by statute has a sort of a strong chair model. The chair is not in a position that rotates. The chair is selected by the governor. And also they don't have term limits. They can continue on without time limitation. So the chair on the committee side is very active and performs some of the function that I would perform for the commission in terms of overall direction of the work. And so when this idea was first proposed, what I suggested is that there would be some administrative work that the managers, for the commission's managers, would need to do. That could be offset, and this was the proposal and it was implemented, by adding administrative staff. And we also did a promotion for Deborah Larrabee, who's the existing SSM. So to bolster the resources of the administrative teams, to take some more routine administrative functions away from the managers. So we'd be doing a little bit more of the admin work for the committee, but we'd be doing a little less for the agency as a whole. And then the other thing is we upgraded one of the attorneys to an attorney 3 on the theory that that would allow for a little bit more independence with the rank and file attorneys. So if this change was made, there really wouldn't be, I don't think, a difference in terms of the allocation of resources between the committee and the commission, because what was formerly Barbara's position would be dedicated 100% to the committee. And what is already an attorney assigned exclusively to the, to the commission. The commission would get Barbara's position 100%. What was formerly a position exclusively for the committee would still be a position exclusively for the committee. The only resources that the agency would be dedicating over here from sort of the overall structure would be continuing to be me handling managerial stuff, but that would actually be reduced quite a bit, I think, by putting an assistant chief counsel here. And I can give you a concrete example, which is we've been doing a lot of recruiting, much more than we usually do. And that's really burdensome. The processes involved in civil service recruitment they require a lot of painstaking, nitpicky work. And Barbara and I were really having to run that even for the recruitment of people over on the criminal team. If we were to do this, this would permit this attorney to handle that recruitment by themselves without requiring us to take the lead on it. Currently, that's not possible because all their attorneys are rank and file, and you can't have a rank and file person leading a recruitment of somebody of equivalent rank. So I actually think it would be at worst a push with respect to the current situation, and at best it might actually be might lighten the administrative load of the general staff and allow a little bit more concentration on the commission side for me and whoever succeeds Barbara down here. Does that answer your question? Okay. I'm going to stop sharing this.
Okay.
Anybody else have any questions or comments? And like I said, I vetted this with everybody who needs to be consulted, and there have been no objections yet. And I guess I'll add one more point, which is that I have started the process for the committee because that vacant position is currently vacant. Mm-hmm. I can work on reclassifying it. Barbara's position is not currently vacant. She is using much of her accumulated vacation time, which is an option in state service. So she's not working, but she's on our books, and the position is not vacant until mid to late May. That's all I had for the executive director's report. Thank you.
Okay, thank you. Any commissioner suggestions is the next item. Any suggestions from commissioners on anything interesting or entertaining? Hearing none? Seeing none? Okay. Legislative program, Brian?
Yeah, thank you. This is Memorandum 2219. And as with the prior memos this year, this is mostly just a status report. Most of our bills for this year have been introduced. We're still waiting on the conforming revisions for the Public Records Act recodification bill. Those are going to be reintroduced as part of the maintenance of the codes bill. And right now, maintenance of the codes is a spot bill. And the intention is that our content will be added when content is added, but we don't yet see that in print. There is one point of decision in this memo, which is that with respect to the estate planning bill, AB 1716 by Assemblymember Manchin, that bill was heard on Tuesday, and it was actually an in-person hearing, although they graciously allowed witnesses to appear by phone, and I took them up on it. So it was approved on consent, which is nice. So at least so far, there's no concerns about it. But when I prepare for a bill hearing, I always try to like go back and reload all the details into my memory because this is something I haven't looked at in quite a while. And in the process of doing that, sadly, I spotted a couple of errors in the recommendation. Sorry about that. Those were just straight up oversights on my part. But they're described in the memo, and the concern is that this bill would repeal 2 provisions. And there are within the chapter 2 sections that cross-refer to the provisions that would be repealed. And those sections were sections that we were not touching, but we need to touch them. So I have set out proposed amendments to strike the references to the repealed provisions. I discovered that too close to the hearing to want to upset the apple cart, especially because the bill was on consent and about to be heard. So I'm with your approval of this change, I'm going to go back to Mr. Manchin's staff and talk to them about making these changes, hopefully before it gets to the floor so that it doesn't have to get amended in the second house.
Right.
So I'm asking for your approval of those changes, and I think I need a motion and a vote.
Is there a motion to approve there were 2 and it's striking out a couple of cross references that I guess
Yeah,
to sections that no longer exist?
The bill will repeal them. Our
Yeah.
bill will repeal those provisions. So this is a conforming change.
So moved.
It's been moved. Is there a second?
Second.
Second, it's been moved and properly moved and seconded. Call the roll, please.
Commissioner Carrillo,
Aye.
Carrion,
Aye.
Cubas,
Aye.
Ebner is not present. Jenkins,
Aye.
King,
Aye.
Simpson.
Aye,
Okay, that completes that memo. Thank you.
great. Item 4, state and local agency access to customer information.
Also mine.
Also, Brian.
This is Memorandum 2220. And this is closing the loop on a tentative recommendation that we distributed last year, in September of last year. And we decided to give it a very long comment period in the hopes that it would enable interested state agencies a chance to review it and comment on it. This is a proposal that came out of our study of government access to customer information from communication service providers, which I generally colloquially shorthand as electronic surveillance. So this is about accessing people's communication records from their service providers. And it's one of the trailing issues that came out of a study we did several years back. And in short, the proposal is that when an administrative agency uses a subpoena, an administrative subpoena authorized under the government code for agencies to use, to obtain customer information from a communication service provider, they have to also give notice to the customer who is the subject of the subpoena. And the conclusion coming out of our earlier study was that this is likely constitutionally required. And moreover, there are other examples in California law where this sort of thing is required. And I think the most squarely relevant one is the California Right to Financial Privacy Act, which regulates government access to bank records, financial institution records. And in that case, if an agency uses one of these administrative subpoenas to get financial records from a financial institution, they have to give notice to the customer. So we circulated that. We gave it a very long comment period. The notice, as I described, the notice went to our established mailing list, over 100 people and entities who've been following this study generally. And I also did a more targeted email distribution to general counsel in a number of state agencies that I cherry picked from the state's table of organization as agencies that are probably likely to use administrative subpoenas in their enforcement practice. And we didn't get any comment. So, you know, it's always a quandary for us when we get no comment as to whether to read that as acquiescence or insufficient outreach. I note in the memo that before we prepared and released the TR, we did get comment from a couple of people. One was a senior attorney that I had corresponded with at DOJ, who we discussed it informally and without attribution because he hadn't gone through the process of obtaining approval from his department to speak on the record. But he was somebody senior in their civil practice, and he said that it's routine for them to give notice to customers when they seek customer records from a third party. And the other was the ACLU of Northern California, who had been commenting earlier in our study when we were first talking about which pieces of it to continue working on. And this problem and the broad outlines of its solution was identified, and they commented on it, and they concurred in the analysis and conclusions that we've reached, and they urged the commission to continue towards a solution. So I think that although they didn't have specific statutory language in front of them at the time, the general thrust and concept of the reform was pretty clear from those materials. So I take that as them agreeing in principle that notice to customers should be required. And so with them, at least, they're on our mailing list. So the fact that they didn't comment on the tentative recommendation, I take that as them being okay with the language. So we don't have complete silence, and the input we did receive is consistent with or supportive of this. And so the question today is whether you are ready to approve this as a final recommendation with or without any changes that you might want to make, or whether you want to take longer and have me try to sort of beat the bushes a little bit to see if I can get some agency counsel to speak up.
Well, I looked at the list at the footnote at the bottom of the first page about the list of agencies that you reached out to, and I'd be hard pressed to come up with more to add to the list, honestly. So it seems to me like, I mean, we could wait if people want, but my instinct is it would be to go forward with the recommendation to the governor and legislature. Any other question? Any other observations from commission members?
I concur.
Really?
Let's proceed.
Okay.
So this is a
No,
final recommendation. I would need a motion and a vote.
Okay. Is there a motion to approve the tentative as a final recommendation?
So moved.
It's been moved
Second.
and seconded.
Okay, I'm going to call the roll.
Call the roll, please.
All right, Commissioner Carrillo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Cubas,
Aye.
Commissioner Hebner is still absent, Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
Thank you. That completes that item.
Okay. Great. Item 5, emergency related reforms, and that's Kristen.
Yes, good morning, commissioners.
Right.
Memorandum 2022-21 discusses the commission's study related to emergency law reform. This is a relatively new study, but one of the things that sort of complicates this study is this area is, of course, still getting a lot of attention, and it is at the forefront of everyone's minds. I'm not going to get into the details of what's presented in the memo, but essentially the memo describes ongoing legislative activity or recent legislative activity in California, the activities of the Uniform Law Commission that's looking at emergency related issues, and briefly describes some of the general character of litigation that occurred related to the governor's emergency powers, specifically in California during the pandemic. So one of the things that the staff started to realize as we were drafting this memo is all of this ongoing activity complicates the commission's work a bit. The beginning of the memo discusses some of the prudential considerations for the commission to take into account. The commission is by statute prohibited from advocating for or against any legislation on a topic that the commission is authorized to work on. The commission has often taken a very, I think, conservative and cautious approach to that prohibition. And one of the things that I think poses some challenges for at least the staff at this point is it's difficult to provide much analysis on this topic, given the pending legislation that's out there. Because if we, look at the different options, what approaches are available, we're a bit limited in what we say because some of those arguments could, for instance, be pulled into like a legislative analysis and suggesting that the commission thinks that approach is either good or not good. That's not a comfortable position for the commission to be in. From a practical standpoint, one of the reasons why the commission, has chosen to sort of stand back in the past is because the ongoing pending legislation actually was covering a lot of the same ground that the commission anticipated working on. And I think the example that was given is the electronic surveillance work. So in that case, there was a bill that covered a lot of the same ground that the commission was anticipating covering. And so the commission decided to sort of redirect its work into preparing an informational report and avoid making a specific recommendation and preparing proposed legislation because, that we anticipated that ground might be covered by the pending bill. So the question before the commission is, how do we proceed with this emergency work? The memo lays out some different options at the end. And essentially, I think one of the big issues and the issue that's kind of receiving the most attention right now is the overall balance of power between the legislature and the executive during an emergency. So there have been a lot of legislative efforts beyond California in the states generally to make some shifts in what the legislature's role is versus what the executive's role is, and whether the legislature should restrict what the governor can do in emergencies. So that's the issue that I think was one of the topics that the commission expressed some interest in working on, but is probably the one that kind of raises the most possibility of conflicts or running into some uncomfortable situations. The commission also considered more narrow focused substantive topics, like looking at the issue of license reciprocity specifically. In this case, the memo notes that there's a uniform act that could serve as the basis for that. It seems unlikely that that would actually kind of run into the same tension, although still possible. Another option is, like we did in the electronic surveillance study, the commission could consider sort of proceeding with focusing on a more descriptive informational course right now, with the idea that we are going to avoid getting into analysis, particularly while there's just a lot out there that we might, come into tension with. The commission could shift course at some point in the future if they decide to do that. If we are looking at an informational report now, maybe several months down the road, sort of the outlook is different and the commission feels more free to sort of make recommendations. The other option is the commission could actually put this work on hold for now and then, revisit it in the future at some point that the commission directs staff. We could, look at the end of the legislative season, push this again to new topics. But really the question for the commission today is, how do they want staff to proceed? Like I mentioned, to the extent we want to move ahead with sort of the broad reform, focusing on this balance of power issue, it would be helpful to get some direction from the commission of how we can navigate that. And just for the commission to give some thought to whether we can fully and fairly deliberate the issue while there's legislation out there that touches on those areas. So
Commissioner Carrillo.
I am feeling like we should pursue option 3, given the array of considerations that Kristen has presented to us. Option 3 is the informational report. I understand the concerns. I have a separate set of concerns that applies only to me because my academic center, the California Constitution Center, is also considering doing some work on this, potentially either just for public interest or as part of supporting the commission's work or potentially preparing a report for the legislature. So in addition to, sort of wearing 2 hats here and trying to keep those things separate, even though they do overlap somewhat. Just wearing the commissioner hat and trying to channel our former colleague Crystal, who frequently advocated for doing nothing out of concern for the valid concerns that Kristen and Crystal used to raise. Given the fact that our role here is typically to weigh in on reforms to existing statutes and making recommendations to the legislature, it does seem to me like in this instance where the legislature is itself actively considering reforms, it's somewhat redundant for us to recommend a set of reforms, given how dynamic the legislative landscape currently is. We have nothing to bounce off against. The law isn't static; it's potentially in flux. So one possible scenario is that it could be a waste of time. We recommend a change that the legislature, has already ruled out and moved forward with a completely different bill that is at odds with or doesn't speak to the recommendation we make. And so, we're speaking in a vacuum and we've wasted everyone's time at that point. And there's other worse scenarios. We could come out with a recommendation that conflicts with the direction that the legislature wants to go, and that's clearly bad. But I also feel like on the other end of the spectrum of incentives here, we've been authorized to study this topic. And I take that as, not quite a mandate, but it's a pretty strong direction from, our direction givers in the legislature that this is a topic that is worthy of study, and it's our job to study things. So I don't feel like doing nothing is an option here, and doing nothing is a plan, but I don't feel like it's our best option here, and it arguably neglects our duty and specific direction to at least take a look at this. So I feel like option 3, the informational study, is the best path here. It's the one that fulfills our mandate and also avoids, to the largest possible extent, conflicts, but also provides some value. Mm-hmm. This is it's a pretty complicated issue. There are national model statutes. There are 49 other states, and there's a federal government emergency set of statutes. So the array of potential policy options and changes that one could make, it's pretty broad. So I feel like there's an opportunity here for us to at least be a study guide or informational source and provide some data and overall perspective to the legislature, even if we stop short of coming down on recommendations. Potentially there could be some pro and con discussion in our memo. Like among these 3 options, 48 states use one of them, one state uses one of them and it's gone badly, and one state uses the other one and they've had mixed results. So providing a little bit of empirical context to the various options, that can potentially be very helpful to policymakers. So I'm interested in what my colleagues think, and I'll stop there.
Brian, did you raise your hand?
Commissioner Carrion has her hand up. I'll wait.
Okay. Yeah. Soshi.
Thank you. I also agree with Vice Chair Carrillo. I do believe that the 3rd option is the best option of the 4 that have been laid out. I'm not going to reiterate the reasons that were very well articulated by Vice Chair Carrillo, but I will add an additional reason is that the informational portion, in addition to assisting the legislators and informing the public about the summaries of this law and what that means and what the reforms may potentially look and the impact, is that it'll also give us enough time to see the movement on all of these legislative updates. And I do believe that is a worthwhile consideration to be able to track what is happening as we do this foundational research that will assist in those decision-making activities.
Good. Brian, did you?
Yeah, I had a couple of points I wanted to make. One, process point. Typically, our resolution of authority has this language in it that requires us to notify the relevant committees when we start work on a topic. This specific grant of authority goes farther than that. And I'll read the language. It says, before beginning a study under this authority, the commission shall provide notice to legislative leadership and any legislative policy committee with jurisdiction over the proposed study topic and shall consider any formal or informal feedback received in response to the notice. So I have been holding off on doing that until it was clear whether we were going to proceed and what direction we were going to head in so that I could give more detail. But if the commission makes a decision to choose option 3, my next step is going to be to reach out to the legislature as directed there and let them know this is what we're working on, so that if they want to waive us off because it would be problematic for us to be doing this work while they're doing their work, they could tell us that and we could take it into account. The same would be true if we decided to do something more ambitious, but we might have gone too far down the road to easily backtrack if in that case. I had another just background point and then a question. The background point is that what the vice chair was describing in terms of like talking about trade-offs is something that we did when the commission was assigned a study of whether charter schools organized as nonprofit corporations should be treated as public entities for the purposes of tort immunity under the Government Claims Act. Okay, when that study came our way, we were directed not to make a recommendation, but to just provide a background informational report. And that's what we did. We did the analysis of sort of what are the policy implications? What is the purpose of governmental tort immunity? How is it applicable to charter schools in this posture, et cetera, et cetera. And then what we did in our final report was we laid out 2 or 3 scenarios, maybe 3 or 4, like you could do this, but if you did that, these would be the advantages, these would be the disadvantages, or you could do this, right, et cetera. And so we did the sort of thinking about the logical structure of the policy issues involved in answering the question, but we stopped short of actually offering our own opinion. And, you know, Kristen could do something similar here. And I think that that was constructive to the legislature because it gave them a resource that they could use without having it have our thumb on the scale. The question that I have is sort of if you have any thoughts or guidance about where to draw the line about how descriptive we should be in expressing conclusions. There was a very interesting discussion yesterday put on by the Federalist Society about this very issue, and our vice chair was one of the speakers. It's available online if you're curious. But the issues that they raised are the sorts of issues that I would anticipate that we would raise too, which things like, what is the degree of permissible delegation by the legislature to the executive branch? What is the degree of statutory specificity required when a delegation is made? You know, the questions like that I think are underlie the alternative approaches that could be taken would be worth talking about, because there's case law and there's constitutional doctrine and all of that stuff that is the landscape of a lot of these issues. But the thing that had us nervous is that this is very polarized in the legislature right now. So it's not just that the legislature is actively considering these issues, it's actively considering them through a fairly political lens. And we were just a little nervous about it appearing that we were taking a side. And I think that it's kind of hard to walk that line between saying, here's what our research shows and our legal conclusions based on it, versus your argument doesn't hold water, legislator. And so I want to raise that and just get a sense if anyone has any thoughts about how sort of cautious we ought to be.
David?
Thank you for the shout out to my Federalist Society thing. If you have
Recommend.
insomnia, I highly recommend it.
just fast forward through the other speakers just to David's part. It'll keep you awake.
I certainly agree with the concern for the need for caution from this body's perspective. And obviously there is I don't want to say a partisan overlay, not even a political overlay, but there's an ultimate policy decision that the legislature is going to have to make after sorting through all the partisan political infighting. Along the way to making that ultimate policy decision, I think there's a couple of important informational points. One of them is the legal analysis. And at some point, somebody's going to put in a call to an esteemed body of smart lawyers called Legislative Counsel. And they're going to have to make not just recommendations, but state legal opinions about what is possible and what is not possible and how likely something is to get overturned or upheld by the courts. That is the province of the smart lawyers at Leg Counsel, not ours. So obviously, it's beyond our writ, and somebody else has that writ. So I would not recommend or endorse this body delving into that territory. The other data point on the way to making the ultimate policy decision that I do think is within our writ is presenting the array of possible policy solutions, and doing something as Brian described that we did in the previous study of saying, okay, well, you could do this. Here's how it's worked out in other places or in the past. Here's variations on that, and here are the positives and the negatives of going in that direction. And we state no opinion on, how you should balance those pros and cons. Like even if there are some cons, you might decide that the pros outweigh them. Here they are. You're the ultimate policymaker, legislature. We all understand that. So we're just trying to help. And I think that is a needle that can be threaded. We've done it before. And obviously, Brian, I completely agree with you. If the formal or the informal word comes back from the legislature for us to stand down, that's the end of it. We take direction from the legislature. So I'm trying to approach this from the perspective of we've been tasked with this, and we have a role we can play, and that role is informational and educational and supportive to the policymaker, and we should do our best to fulfill that role within our writ until somebody tells us to shut up, at which point we will.
Yeah, I just for what it's worth, I concur with pretty much everybody said this kind of the same thing, that this is, and I think the analogy to the charter school thing was probably an accurate one, because the charter school thing is a very highly politicized area of law and policy as well. I lived in that space for 35 years. So I think the cautious providing information, the list of options, the pluses and minuses, I think is, but without going farther and sort of weighing one side versus the other, is probably a pretty good approach to dealing with the task that we've been charged with. And then as David says, if the legislature says back off, not the right time for this, then we would back off. Any other comments or observations from
I have a
commission?
question and a
Yeah,
comment.
proceed.
For staff, is there at this time any concern that some of these issues that you're describing regarding the procedure and the standing law on positions essential or necessary for us to create that kind of informational analysis? And then second of all, if you know of those issues that you think you may need to address, it would be important, I think, for the commissioners to know. And second of all, if as you work through, if we move forward overall with an informational approach, would it be possible as you go through this process and those issues come up that you raise them to the commission, of course, as you've done in previous studies, where this is an issue that, it may cross the line and we didn't realize it until we actually kind of like delved into the law and really did that deep analysis that is required for these kinds of studies.
Brian, do you want to take that, or you?
Yeah.
I'm fine with you answering if you've got an answer.
Okay. Yeah, no, I mean, I think that that is definitely the approach that we would take. What you described is, I mean, at this point, to answer the first question, I don't foresee where those issues are, but certainly as we get into the analysis, once we start touching on those issues and start seeing that there's a risk, that would be something that we would bring back to the commission and point out and sort of explain what the landscape is and what the constraints the staff feels are. I mean, similar to kind of what we've presented today in terms of like the overall study. So we could do that on a smaller scale as we go forward and, you know, run into issues that pose such tensions.
I have a question.
Yeah, Brian.
Just occurred to me when I do the outreach to the legislature to let them know what we're proposing to do and to let them know that we're open to hearing their advice. Should I acknowledge the possibility that they might want us to go ahead with a substantive study and the development of recommendations instead of wanting us to stop or short of that? I saw an expression of anguish on one of the commissioners' faces. I won't pick him out. It's in the permanent record, though. Did you
I
have a thought on
suppose-
that, David?
Victor, was it?
Yeah, I suppose be careful what you ask for, right? I mean, you might find someone quite more than willing to offload as much as possible onto the commission. So maybe silence is the more prudent way to approach it. You know, if they want us to do that, they'll say it. We don't have to necessarily invite extra work, which depending on the person, they'd be more than happy to give you.
Yeah, fair enough.
I concur.
Yeah.
I have one more comment, and
Yeah.
I'm sure you may have already thought of this. In addition to interfacing with the legislature and making sure they're comfortable with where we're headed, it seems to me there are a lot of references here to the Uniform Law Commission, and we lost our built-in contact with them, right? Because our current commission. Carrie, you're still on both? Okay, all right, good. Well, then we're in touch with them. Okay, I wasn't aware that you were still on both commissions. Great. I just want to make sure that we work with them closely so that we don't step on their toes or whatnot. Thanks.
My only comment about this is, and I defer to Rick about how to contact the legislators and how to deal with that, but I would imagine there is a legislative record of that discussion or who the author was that put that assignment for us. So I don't know if you've looked through that to see what was the intent or what was the discussion. I usually like to refer to those.
Yeah.
But anyway, Rick might know better about how to approach the legislature and their intent and the members, et cetera.
Yeah, we know who the author and who the author of the whatever the resolution was.
Yeah. Well, and the language tells us committees with relevant jurisdiction
Right.
and leadership. So we'll find those committees. We'll reach out to chairs and vice chairs and talk to the people in the speaker's office and the pro tem's office. So they usually have staff assigned to different subject matters. We're not actually called on to do this, but we might also reach out to like the governor's office.
I was going to say the same thing. Yeah.
Emergency services and just make sure that they're okay with us operating in this space.
Right. Becky just hired a new ledge person the other day.
Do you have a name?
Christy Boma.
Okay.
Yeah, David.
Having already stated my views on this issue, Brian, would we have a quorum issue if I abstained from the vote on this?
No,
we're
quorum
okay.
is your presence.
Yeah, okay.
And we only have a minimum vote number required for final recommendations.
Okay. I feel like I should abstain. And in the interest of full disclosure and avoiding the appearance of impropriety, to the extent that anyone doesn't already know this, I'm the executive director of an academic center at the University of California, Berkeley School of Law. It's called the California Constitution Center. My center has done some work on emergency powers already. We plan to continue that work. Some of it may have my name on it, some of it may not. The work that my center is going to do, it will go on independent of whatever this body decides to do. There is a scenario where this body moves forward and my center plays a supporting role, potentially assisting or providing, at least providing information for the staff of this body to consider, again, in a purely informational academic support role, not attempting to influence any final decisions. And I am trying to be conscious of the fact that I wear two hats here in this particular context. So I don't want to give the impression that anything this commission does will affect what my center does or the other way around. But there is a scenario where there's mutual assistance or at least cooperation or awareness of the two tracks of work that are going on. And there's also a scenario where this commission decides not to move forward with this and my center just proceeds on its own and makes whatever recommendations or files a white paper or study or whatever with the legislature. And that obviously would be totally separate from whatever this commission does or doesn't do. So I just want to make sure everybody's clear about that. I'm happy to answer any questions about it. I don't want to give the impression there's any kind of secret backroom, smoke-filled room dealings going on between a shadowy liberal organization. This is all totally above board, and we all work for public institutions. And I think there's a common goal here, and there may be some overlap in the work between my center and the commission. I feel like I should make sure everybody's apprised of that.
Got it. Okay, no, that's not a problem. Thank you.
So it seems like the commission has decided that the informational report option is direction that they want to move in. If we could just get a vote on that, just so we can kind of make a note of that in the minutes, that would be great.
Yeah. Ryan? So is there a motion to raise your hand if you want to make a motion, I guess. Yeah, okay. It's been moved. Is there a second? I'll second.
And I'll call the roll. Commissioner Farian? Oh, Commissioner Carrillo, sorry about that.
I will abstain.
Okay.
I'm sorry,
Cuevas?
can you clarify the motion, please, for me?
The motion is for the commission to proceed with an informational report, which is option 3, and then
Number
memorandum.
3. Got it. Aye.
Okay. Commissioner Jenkins?
Aye.
Commissioner King?
Aye.
Commissioner Simpson?
Aye. Okay,
All right, thank you.
we continue. Thank you, everybody.